And we will begin with General Orders number 22, House File 809. Senator Kiffmeyer.
Thank you, Madam President and members. So we are dealing with House File 809 today. Senate File 702's companion is House File 809. The purpose of this bill is to prohibit the use of taxpayer dollars to pay for abortions. Well, no, let me say, it's not just abortions. That's a little bit too clinical. What we are doing here is to prohibit the use of taxpayer dollars to pay for taking the life of an unborn child. Which reminds me of a little girl named Amber. As a nurse, I took care of baby Amber. Baby Amber weighed just over a pound, the size that many lose their lives in the process of an abortion. It's real. This is taking of life, and it is real. The majority of Minnesotans find taking the life of an unborn child to be against their conscience. But not only that, what really bothers them, they understand that others may have a different conscience. So even in the area of taking the life of an unborn child, to be forced to pay for it through taxpayer dollars is extremely bothersome and unjust. I handed out a flyer just now. Of note that of the 62% in a poll that said they were pro-choice, those 62% were opposed to using taxpayer dollars for abortions that take the life of an unborn child. Matter of fact, 44% of Democrats were against using taxpayer dollars for an abortion that takes the life of an unborn child. So where are we at in regards to policies nationwide? 32 states and the District of Columbia certainly right now take the federal position, which is no taxpayer money goes to funding abortions that take the life of an unborn child. There are 13, like Minnesota, where we are under a court order that we must pay because federal dollars and medical assistance cannot be used to fund abortions, the taking the life of an unborn child. This court order requires it, and Minnesota must pay 100% of the cost. Just to know that in Minnesota, prior to Doe v. Gomez, taxpayer dollars were not used to pay for an abortion in the taking of the life of an unborn child. Minnesotans did not vote to change this policy. The legislature did not vote to change this policy to now pay using taxpayer dollars for abortions that take the life of an unborn child. Matter of fact, Minnesotans do not want their taxpayer dollars used to fund abortions that take the life of an unborn child, the most vulnerable amongst us, the most innocent amongst us. Taking lives of unborn children, especially through medical assistance, means that those who are low income and minorities will end up having more abortions, losing the lives of their unborn children at a higher rate and an increasingly higher rate as years have gone on. Certainly, as my mother said, as the oldest of 14 children, which one of them wasn't worth life? Well, certainly every single one of them that I think of is a contributing member of society, and you know what? I bet it was not easy for my mother. She was low income, very low income, but she valued life and sacrificed my mom and dad and instilled those values in all 14 of us. I don't consider it benevolent to give abortions to those who are of low income or minorities. I've always supported taking care of those in other means. And by the way, I hear from parents all the time, would-be parents. There are waiting arms for those babies. They just need a chance to be born, and there are people that are waiting who want those babies. They hunger for them. Their arms yearn to hold that baby. Just give them a chance. One of the things that we see as we go through these things is a value for lives, and that is my commitment and why I am presenting this bill today. And members, I urge your support to vote for House File 809 to protect the lives of the unborn babies and give them a chance. Thank you, Madam President, and with that, I'd like to ask that the Senate would come under call.
Senator Kiffmeyer has placed the Senate under call. Secretary.
Yes, Madam President.
For the entirety of the bill?
Yes, Madam President, for the entirety of the bill.
Senate is under call.
Good. Mr. President,
Senator Kiffmeyer.
Mr. President, I move that further proceedings under the roll call be dispensed with and the Sergeant at Arms be instructed to bring in the absent members.
The Secretary will close the roll. Do we have to vote? All right. On the motion to close the roll, all those in favor say aye. Opposed? The ayes have it. Senator Kiffmeyer, do you have any further words to say before we get into discussion?
No, Mr. President, not at this time.
Further discussion? Senator Kent.
Thank you, Mr. President. This is obviously a challenging issue. People have very strongly held beliefs on this issue in general and on this bill in particular. I hope that we can always try to discuss different perspectives from a place of respect. I know we have a tradition of having serious and thoughtful discussions, and I hope we can continue that. Each of us represents people in our communities who hold a wide range of beliefs on this subject. And I know when I think about my own community and the discussions I've had with people, there's great dedication and thoughtfulness into what everyone believes. And I think it's important that we give each other some space and some respect on that. Having said that, I do rise to oppose House File 809. There are many reasons to oppose the intent of this bill, principally that it discriminates against women based on their financial situation. And I oppose this bill for that very important reason, among others. But having said that, I want to rise at this point to speak against this bill on, frankly, just a more practical basis. This bill will ultimately not be enacted in Minnesota for two significant reasons. First of all, Governor Dayton has vetoed essentially the same bill in the past and has indicated this year that he will do so again. And when he vetoed the bill in 2011, Governor Dayton stated that it infringes on a woman's basic right to health and safety. And the second very significant reason is that it is unconstitutional. Nearly 22 years ago, in 1995, the Minnesota Supreme Court ruled such restrictions unconstitutional. In their ruling, the court held, quote, that the difficult decision whether to obtain a therapeutic abortion will not be made by the government, but will be left to the woman and her doctor. 22 years since this ruling, this is established law. This bill will not change the legal precedent, and efforts to enact it would be met with lawsuits that would cost taxpayers, and ultimately, as all parties understand, it would fail. And I think it's interesting, when we were in our break recently, I was watching some of the events happening in Washington, D.C., and there's been a lot of discussion today about health care. And I thought it was very interesting that those who have supported this new health care bill that just passed Congress, I actually was listening to one of the representatives from my former state, Louisiana, and he talked passionately about how important it is that decisions be left between patients and their doctors. So I think it is important that we hear that and reflect on how that affects this case as well. Members, we are close to the end of this session. This is a budget year. We have a fundamental obligation to the people of Minnesota to do that work. This, in my view, is not the time to bring divisive social issues that we know will never be enacted. And so, therefore, I would ask members to vote no on House File 809.
Thank you, Senator Kent. Senator Hall.
Thank you, Madam Chair and members. This is probably the most significant bill we will have this year, and I'll tell you why. 1974, my eventually wife was pregnant before we got married by me. And I went to my minister. Now, this is a year after Roe versus Wade. I went to my minister and one of my brothers, and I asked them for wisdom. Yes, we were engaged, but wisdom on life coming up. And both of them said to me, I would abort this child because this child will probably pull you down because you're still finishing up college. You don't have a job. And can you imagine, now 40-some years later, me giving up my oldest son and my 4 granddaughters? There's a lot of times we think we can't afford things. I would not have even thought about something like abortion. So I'm grateful now we have the technology and the science in our society to know what's right and what's wrong, to know what life is and when life begins. I think we all know deep inside there is never a good time to take a life, and especially the life of an unborn baby. America, I believe, has finally woken up, taken its head out of the sand, and can see clearly now. This bill is one small step, I believe, to stopping the abuse that we have had for years. Will it change it all? No. But should the state be paying for this abuse? I don't think so. So please, today, vote for life.
Senator Pappas.
Thank you, Mr. President and members. And I rise to oppose this bill. I oppose the bill because I believe it does discriminate against women based on the type of health insurance they have. This bill challenges it challenged the established law that ensures women will have access to the reproductive health care they need, regardless of their financial situation. Minnesota Supreme Court in Doe versus Gomez broadly interpreted the right to privacy and held that the difficult decision whether to obtain a therapeutic abortion will not be made by the government, but will be left to the woman and her doctor. Other states have paid millions of dollars in legal fees to defend unconstitutional restrictions on abortion rights. I don't believe that politicians should be able to deny a woman's health coverage just because she's poor. In states that do not provide Medicaid coverage for abortion, most low-income women still manage to obtain abortions. Many are forced to divert money from living expenses such as rent, food, utilities, and other bills. Eliminating MA coverage for abortion creates a two-tiered system in which lower-income women do not have the same freedom to make their own healthcare decisions based on their own situations as those who can afford abortion. Finally, coverage bans don't end abortion, but they do push the procedure later into pregnancy. In states that deny Medicaid coverage of abortion, studies have shown that women postpone the procedure by 2 to 3 weeks to scrape together the funds to pay for it. Or, heaven forbid, they try a self-imposed abortion. And that can end in severe injury and sometimes death. An abortion, if they have to pay for it, can cost a woman on Medicaid nearly a third of her monthly family income. As Senator Kent said, this legislation has previously been vetoed by Governor Dayton, and I expect it will be vetoed again. So please vote no.
Thank you, Senator Pappas. Senator Eaton.
Thank you. I'm here to echo, I guess, Senator Pappas's words. This bill discriminates against people because of their income and their type of insurance. You shouldn't be able to discriminate against what health care you pay for just because someone's poor. The coverage bans do not end abortion. They just push it later in the pregnancy. And this will result in a costly lawsuit for the state of Minnesota. North Carolina paid over $1 million, and Wisconsin just recently paid $1.6 million in court costs to protect this bill. So I think we're wasting time, and we're looking at wasting taxpayer dollars by pursuing this. I am confident the governor will veto it, and I know the courts will rule it unconstitutional.
Senator Kiffmeyer.
Thank you, Mr. President. I just want to respond to a couple things here. Number one, the governor may veto a variety of things. It doesn't mean we as legislators don't vote what we believe in or what we think is right. We don't stop voting on things because of that. That's not the sense of everything we do here in the Senate. We take those votes and do our very best. And certainly voting your conscience is worth it. on matters and issues like this, it is worth voting your conscience. In regards to being unconstitutional, first of all, the U.S. Supreme Court upheld the Hyde Amendment, which led to the federal government not paying with taxpayer dollars for abortions and taking the life of an unborn child. And really, for us to say anything is unconstitutional, as one judge once said, only a judge or court can say what is constitutional and what is not. Any of us can have an opinion, but it's not the same as a court. In regards to legal precedents, I want you to know that legal precedent has been overturned before or has been modified. And so let's realize that we can have that same situation here, especially in the light of science. When you go back and read the Roe v. Wade, you realize that at that time there weren't ultrasounds, there weren't the opportunities. There was a great deal of questions about when does, quote, life begin, as if, first of all, for me, recognizing that the day after birth, the day before birth, and you continue going on, it's a continuum. It goes all the way back to the point of conception. I mean, that's a continuum, whether it's an eagle or anything else at that moment and going forward. It's a matter of size, a matter of functioning, and certainly the unborn child needs the protection for 9 months before being able to exit and then still needs lots of protection. If you abandoned a baby after they were born, they still need to be taken care of. Decisions to the doctor, yes, but remember, this is 2 lives. You have the mother and you have the unborn child. And the decision of one greatly affects the other. And so the choices, remember, are not just for the one. We do have important things to do, but that doesn't mean that as we are waiting on negotiations, doing other things, that we can't take up those bills that are very appropriate, that recognize our conscience and the work that we do, that are valid for us as a Senate to do so. I think the recognition of health care is, again, 2 lives. Let's have health care for both of them. Thank you.
Senator Dibble.
Thank you, Mr. President. Mr. President, members, decisions about if, when, and with whom to start a family are very, very deeply personal and private matters. I trust women to make the best decisions for themselves. When a woman with her family, with her counselor, her faith leader, her doctor is facing a decision like this, that's certainly not the moment in time when I want to intrude from this place on the Senate floor with the awesome and coercive power of the government and the law in that woman's life. This is a fundamental question of civil and human rights and whether we're going to treat some members of our state and community differently. A woman can never be equal if she's denied the basic right to make decisions for herself and her family. That's just a simple fact. A woman can never be equal if we take her decisions away about how she's going to form her life and her family and her future. Pregnancy should never be mandatory. Decisions, the sovereignty and autonomy over our own bodies is a basic right. And these things, of course, should never be less true for a woman based on her race or her income. If you're not moved by any of these arguments, maybe a little bit of self-interest will appeal to you. Those countries that relegate women to second-class status have far lower standards of living and far less functional economies. It's estimated that up to $12 trillion is the cost to our international economy on the basis of treating women as second-class citizens with inferior status and less autonomy and decision to make over their own lives. So members, I appreciate and respect the struggle that some have articulated around the decisions they made for themselves when they were younger. They got to make those decisions in consultation with their significant other, their spouse, whomever else they wanted to consult. I don't think they were looking to this room and this chamber and all of us to make that decision for them. Coupled with the fact that if this is blatantly on its face unconstitutional and is headed for a veto, members, I would urge a no vote. Thank you.
Senator Hall.
Thank you, Mr. Chair. Just to respond a little bit, if I may, to discriminate against women, what about the little baby girls that are killed? A little more than discrimination. Discriminate against people. You know what? These are people too. Taxpayers putting out dollars. Never is it a waste to spend money to save a life. And I wouldn't intrude. I will intrude to save a life. Human rights start at life. And taking life is the worst you can do in a human right. There is something I do agree with. Women will never be equal without a choice. If you don't give life to some of these little girls, they will never have a choice. And I do appreciate respect. And I think we should always have respect for each other. And we should have respect for those that are unborn and the life and the potential that those could be. Respect.
Senator Chamberlain.
Thank you, Mr. President. Will the author yield for a question?
Will the author yield? The author will yield.
Thank you. Senator Kiffmeyer, just a couple of questions to confirm a couple of things. Does your proposal prohibit or any way get in the way of a woman making that very personal decision for herself?
Senator Kiffmeyer.
Thank you, Mr. President, and Senator Chamberlain and members. No. The purpose of this bill is in regards to who pays. And it's important to remember that this bill is about taxpayer dollars, which is our purview as the legislature. And this bill has nothing to do with that choice, as you mentioned, Senator Chamberlain. It is about the paying of that situation.
Senator Chamberlain.
Thank you, Mr. President. Senator Kiffmeyer. So you kind of got into the second question just for clarification. So this bill does not, your proposal does not prohibit a woman from making that very personal, private decision, nor are we trying to interject ourselves into that. So secondly, the funding, and you kind of alluded to this. So the funding, what we're saying is, and by, as you said, the Hyde Amendment, we're allowed, the states are allowed to say that taxpayers do not have to pay for abortions. So would you just clarify one more time for the body and the public that provision? What money is not going to be used to pay for the abortions? Thank you.
Senator Kiffmeyer.
Thank you, Mr. President. Thank you, Senator Chamberlain. So in regards to the money here, just recapping a little bit from before, the federal government's current policy under the Hyde Amendment is to not use taxpayer dollars to pay for the funding of an abortion, the taking the life of an unborn child. And so for Minnesota, it means 100% of it comes from Minnesota taxpayers in regards to our medical assistance program in particular. I hope that answers your question, Senator Chamberlain. Thank you.
Senator Isaacson.
Well, again, I find myself in this familiar place this session where I can almost barely stand the hypocrisy of the bills I see coming forward. You know, Senator Hall, I've had an awakening from your comments. I've had an awakening when you said this is the most important bill we're going to see. Suddenly, why this session is looming in such a disastrous place. If that is truly the focus of the Senate majority, then I can see why we're in some trouble. I hear us talking about respect and life, but all I have to do is look at your priorities on any other issue when it comes to health care, and I have a very clear understanding of where your respect and life is, and I'm going to call out one specific one. We have a looming disaster coming ahead of us with people with disabilities and PCAs that are not being paid and place shifts that are going unfilled, and we do absolutely nothing about that in the budget despite having a $1.6 billion surplus. And then I hear the audacity of some members across the aisle to talk about how we need to respect life on a bill that has no chance of becoming law and is unconstitutional. So there's really no chance your bill is going to affect anything of what you're talking about. But where you hold all the cards and can make all the difference in the world in the life of people with disabilities and K-12 funding, you refuse to do so. So I really don't think I want to hear one more word about that, because I cannot stomach that hypocrisy any longer.
Senator Matthews.
Thank you, Mr. President. You know, I joined the HHS committee midstream this year, and in my first hearing in that committee, these were the bills that first came up. It was quite an experience to have this as my first experience in HHS. And I sat and I intently listened, and I know that there are people out there who will encourage to not listen to people on the other side, especially when it comes to this issue. But on that meeting, I did sit there and listen. And I listened intently, and I looked across the room at those who were sitting there, those who were passionate on both sides of this issue, and I saw that there were even people who supported abortion that had a genuine compassion, that wanted to help women in difficult situations that they were in. And I strongly disagree with the solution that they're presenting, but I'm grateful that there are so many people out there that have that form of compassion to try to reach into someone's life and help make a difference for good. And that's why I think I want to see more reliance on our neighbors, on our community, on our churches, on our places in our situations where we have grown up in, rather than full reliance on the government, because it can be much more personable and much more impactful in a person's life if we will reach out and try to help someone who is in a difficult situation. I wish we were at a place where anyone could walk into any church in any city in this entire state in that kind of situation and find the help and the care that they need in order to not only help and improve the mother's life, but the baby as well, whether that's in that family or in some other family who's waiting to adopt. And I hope, Mr. President, that we can help move away from presenting two false choices. On the one hand, the argument seems to be that if we're going to help the child, it's going to harm the mother. And on the other hand, the argument seems to be if we're going to help the mother, it's going to harm the child. And I'm here to say those are two false choices. There are other ways that we can help this situation that can help both the mother and the child. That's been my focus. I've served as a pastor of a small church in my community for a few years before. I had families that had difficult situations. In a family situation like this, there's a mother, there's her child, and there's a father involved, whether he's in the picture or whether he's skirting his responsibility. And it fires me up, too, that there are so many fathers out here that do shirk their responsibility. And I do want to encourage them to stand up, grow up, and accept responsibility for the choices they made, too. But I even had a situation in my church between this family where the father was making terrible choices that were damaging his family, was damaging the relationship there. I was most upset at him, and the counsel and my passion for him was to try to encourage him to do what is right too. I hear from the other side that we want to have abortion safe, legal, and rare. And while I don't agree with all of those points, I think we can make steps in that direction, and I want to see where there's action in accomplishing that. And so that's what some of these bills are coming forward to try to do. And I know that my generation, this younger generation that's growing up, every scientific and medical technology breakthrough that we're experiencing is just showing more and more, it's revealing the truth about how life does start from the moment of conception. And my generation is stepping up, and they are recognizing what the truth is. And I'm grateful for that. I'm going to keep encouraging that. I'm going to keep encouraging mothers that I see to make the right choice, to see what can be done for both her good and for the child. And I'm grateful that the culture appears to be moving the right direction. So these are small steps here today, but it is with a heart of compassion for all the people involved as to why I am casting my vote in support of these bills. This is a small step today. There's more I wish I could do. There's more discussions that will be made, but there is a growing number of people across this state that always have and will be passionate about this, and I'm going to encourage them. If they're going to be passionate about it, then they need to become passionate about it. And I look forward to the day where we can see that in full effect in this state and in this country. So I encourage a yes vote.
Senator Schoen.
Thank you, Mr. President. Well, I've heard discussion. We're saying we're not prohibiting a choice to do so, but this certainly prohibits safe access to the choice you claim that you're trying to preserve. Make no mistake about it, women will continue to get abortions, and they won't be safe. We've seen that throughout history, and that puts our families further at risk. Talking about our daughters, I have an 11-year-old daughter, and I'll say this as I look into the camera right now, that your dad's always going to be on your side for your choice. And, you know, Senator Matthews, churches are not government. The government isn't limiting your ability to counsel your parishioners on their choice to come to you to receive help or any guidance. We don't block that one bit. If that's their choice, they get to do that. Government shouldn't limit safe health care to the poor, and especially poor women. What you do at your church is not the purview of government. We've kept that separate. This is not the place for that argument. I understand our moral guidance comes from our faith, but our government is guided by those that we serve, and that is every person in our community. Senator Kiffmeyer, I won't ask you to yield because I already know the answer. I asked you this in committee, but you've not budgeted for the impending lawsuit that will come even if this were to pass. We know it won't pass, or it won't get signed into law. It'll get vetoed this time, and I've been here a few years, just like you have, and this comes back repeatedly. And when the GOP is in the majority, then this bill moves on, and we get to actually get it to the floor, and we continue to have these conversations. But this is also not fiscally responsible. We know what will happen with it, and there is no money allotted for the lawsuit that will be coming, which will be in excess of $1 million+. We need to do better by the people that need our help, no matter what it may be. As it comes to health care, as Senator Isaacson pointed out, there are many other pressing issues here that Minnesotans are counting on us to get done and to make sure they have access to across the spectrum. Please vote no.
Is there further discussion? Senator Kiffmeyer.
Thank you, Mr. President. So I just want to mention, though, that Dr. Gosnell and the horrible situation out east where women were horribly abused, thinking they were getting an abortion procedure and it's all supposed to be so safe and good. Well, it wasn't. It was disastrous. And so I just want to make mention of those, and that is not the only one. And every bill can go to court. Any bill can go to court. And it is custom of the Senate and of the legislature, any bill we pass can go to court. We don't put money in for lawsuits. You'd have to do that for every single bill. Thank you, Mr. President.
Thank you, Senator Kiffmeyer. Is there further discussion? Hearing none, the Secretary will give Senate File or House File 809 its third reading.
House File Number 809, a bill for an act relating to health limiting use of funds for state-sponsored health programs for funding abortions.
Any further discussion? The Secretary will take the roll. Members, we are under call.
But that's going to be a mess. That's going to be a mess. Okay, yeah. Let's just let it go. Okay? Yes. Okay. Yes or no? Yes. Okay. And you can move on to making others. Right? Okay. All right. Thank you so much. Bye-bye. Yep. Yep. What is this? Oh, this is final passage. Oh, good. And we're done? Yeah. So who besides Eaton? Is it yes or no? Huh? Yeah. Who besides Eaton? That was it. How do you get, oh, 35. So what's the problem? Oh, Bach's not here.
Secretary will close the roll. There being 35 ayes, 29 nays, the bill is passed and its title agreed to. The next bill under consideration is Senator Fischbach's House File 812. Senator Fischbach.
Mr. President, I move that the amendment made to House File 812 by the Committee on Rules and Administration in the report adopted May 1st, 2017, pursuant to Rule 45, be stricken.
Senator Fischbach, could you explain the motion?
Thank you, Mr. President. It is literally one word in the title, and on 704, they say requiring licensure of certain facilities, and in the House File 812, it says requiring licensure of abortion facilities. So I renew my motion.
On that motion, all those in favor say aye. Aye. Opposed? The ayes prevail. Senator Fischbach.
Mr. President, House File 812 would require licensure of certain abortion clinics, and I will just quickly go through the bill. In the first subdivision, it would define the abortion facilities and the language that it would make a license necessary is there. In D, in the section D there, that's where it explains that a license needs, or where a clinic that would be looking for licensure needs to be accredited by an industry organization or membership organization.
In E, subdivision E, or excuse me, subdivision 1, section E, that would state who has standing. In subdivision 3, it talks about a temporary license for those clinics that would be opening. And subdivision 4 talks about the details of the application. And a little bit further down there, it does provide for the inspections in subdivision 5, and those would have to be at least once every 2 years. In subdivision 6, discusses the suspension, revocation, and the refusal to renew, and that is tied to existing statute that is there, so they would fall under existing statute. In subdivision 7, it talks about the fees, and that fee for that licensure would be $365, also for a temporary license. And in subdivision 9, we talk about the records and how the records would be kept at those clinics, and that is also tied to existing statutes that would be, and the existing statute includes patient rights and access to records. So that has been, those statutes have been fully vetted. In subdivision 10, we talk about the severability clause, which is becoming more typical around here. And finally, on the final page in section 2, which there is an appropriation for $55,000. And I think that this bill, with the licensing of these, I failed to point out that it is only those clinics that do 10 or more abortions a month. And I think that this bill relies on the abortion industry itself, and that's why that accreditation is required. So it would be done potentially through the National Abortion Federation. And so it relies on the industry's own standards and inspection, not inspections, and accreditation, and the industry's own standards. In Minnesota, this would be in response to the fact that in Pennsylvania, we had the horrific sites of the Gosnell Clinic and what was going on there. And this bill would prevent those things from happening in Minnesota, because any clinic that would then potentially come online into the future would have to be meeting these standards. And the 6 clinics that this would affect in Minnesota now would have to meet that standard. And I think this is about patient safety and about making sure that Minnesotans are served properly in those clinics. And I would appreciate a green vote. Sorry.
Any further discussion? Senator Klein.
Mr. President, I have the A1 amendment.
Secretary will report the amendment.
Senator Klein moves to amend House File Number 812 as follows. Page 1 after line 5, insert. This is the A1 amendment.
Senator Klein.
Mr. President, existing Minnesota statute covering abortion procedures contains mandates requiring physicians to recite certain statements to the patient about the procedure. Minnesota Statute 145.4242 requires doctors to describe certain medical risks, including the risk of breast cancer, danger to subsequent pregnancies, and infertility. Mr. President, leaving aside for the moment the falsehood of these particular statements, which are written into Minnesota law, I want to describe the merits of my amendment. The A1 amendment sets a standard that healthcare providers will not be required to provide information that is not based in the medical evidence or informed by a patient's unique circumstances. It is a physician integrity amendment. It establishes our trust in scientific inquiry and in the protected nature of the physician-patient relationship. I offer the amendment as a proponent of small government, as a legislator who believes our job is limited to keeping the roads repaired and the other basic duties of running a state. I am repelled by laws which place mandated words in the mouths of doctors or in any citizen, for that matter. I offer the amendment as a defender of science and skepticism. Mr. President, our medical knowledge base is in constant flux. 20 years ago, we routinely prescribed estrogen for postmenopausal women until we discovered that it was raising their risk of breast cancer and stroke. In some circumstances, we still prescribe estrogen, but it is uniquely tailored to a patient's medical profile or personal circumstance. Clearly, a clumsy legislative effort to mandate recommendations or to codify medical advice would stumble either over its own obsolescence or its inapplicability to a unique patient. But our current law does exactly that regarding abortion. It places medical advice which has now been proven false and outdated into every exam room, regardless of circumstance. I offer the amendment as an advocate for fiscal prudence. When I introduced this amendment as a bill this session, an associated fiscal note projected $414,000 in decreased costs to the state over the biennium, largely due to the cessation of printing materials. This is a real savings that could be applied to our Health and Human Services budget, real savings in the Health and Human Services budget with a fiscal note. Above all, I offer the amendment in defense of the dignity of women. Current statute, which mandates a short lecture be delivered to every woman who seeks an abortion, is paternalistic, pedantic, and patronizing. No self-respecting Minnesotan would sit still for such a moralizing discourse, and it can't be overlooked that this particular homily will be delivered only to women. How did that come to be? And can we possibly imagine similar language enacted for men receiving prostate screenings or baldness therapy? I encourage your support for the A1 if you support small government science, fiscal savings, and most of all, the autonomy of women. I ask for a roll call, and I stand for questions, Mr. President.
Roll call is asked for, will be granted. Senator Fischbach?
Mr. President, I rise to a point of order. I would question the germaneness of the A1 amendment under 35.2. This does not, and I can offer advice.
Continue with your advice, Senator
Mr.
Fischbach.
President, the A1 amendment basically repeals the Women's Right to Know law that was passed several years ago, and it has nothing to do with clinic licensure. That has to do with the women's right to know and the information that they're provided. This has to do with clinic licensure.
Further advice, Senator Klein.
Mr. President, House file that we're discussing, 812, discusses healthcare professionals, and the amendment relates to healthcare professionals, and it relates to what those professionals are allowed to discuss with their patients in a medically accurate manner. It addresses the same underlying legislation, Chapter 145. Both the amendment and the bill address Chapter 145. Lastly, Mr. President, the bill alludes to the health, welfare, and safety of the patients of Minnesota, and the amendment empowers physicians to meet standards in the physician-patient.
Further advice? The ruling of the President is that the amendment appears to be too far afield from the specific nature of House File 812. The point of order is well taken. Further discussion. Oh, Senator Schoen.
Thank you, Mr. President. I just wanted to point out that what's disappointing in judiciary, we did have some discussions around this bill on data privacy, Mr. President, and that appears to have been removed from the bill. I've been a patient at Planned Parenthood, and when you walk into that clinic, when someone checks in, they check in with security. You go through a fenced-in area because we know the zealots that target these clinic locations that provide health care for a lot of our citizens. I think it's important to understand that this bill, when asked for applicant information and those that work at the clinic, you're jeopardizing their safety, Mr. President. We know that. We discussed that in your committee. And when we look at these attacks across the country, the terror attacks that take place on these clinics, it is very unfortunate that we would set a bill into place that would further jeopardize the staff that are just there to provide health care.
Further discussion, Senator Kiffmeyer.
Thank you, Mr. President. Would Senator Schoen yield to a question?
I'm sorry, Senator, could you repeat that?
Would Senator Schoen yield to a question?
Would Senator Schoen yield? He will. Senator Kiffmeyer.
Thank you, Mr. President. Senator Schoen, you mentioned health care from Planned Parenthood. Could you tell me what health care Planned Parenthood provides other than abortions?
Senator Schoen.
Well, thank you, Mr. President. I'd be happy to. They provide testing for communicable diseases. They provide advice and counseling on other healthcare related incidents. They also provide contraceptive care, which I'm pretty sure that as a professional in the nursing industry, Senator Kiffmeyer, that you know that contraceptive care is also necessary for other issues other than to prevent unwanted pregnancies and to keep women healthy. But I believe we're in nursing. I bet you could provide a better explanation than even I could as a total what Planned Parenthood and other clinic services they provide.
Any further discussion? Senator Ralph?
Thank you, Mr. President. It was referred to earlier on the floor that people are going to have abortions and that some of them are not going to be safe. Some of them are going to be safe. It seems that if we're going to allow abortions to take place, then the way you make them safe is, first of all, you don't do the procedure, but we're not going to do that. We're going to allow the procedure. The second thing is that we want to take every possible step, and I don't believe there's anybody in this room that would deny taking steps to ensure the safety in a procedure that does have risks would be contrary to good thinking. This bill does not attack abortion clinics. This bill does not try to put them out of business. This bill tries to make them safer. I am very concerned. We are dealing with the loss of one life already. I am concerned that by failing to license and inspect these premises, we are doubling down on death. We are taking a chance that we will have not one loss of life, but two. No matter how small that chance is, if there is any way that we can reduce the possibility of that occurring, we should certainly explore it and put it into play. As has been stated, the licensure procedure here adopts the abortion industry standards. More importantly, it provides for inspections to help to ensure that we do not have unsafe conditions where women are forced to make a choice of having an unsafe procedure or not a procedure at all. So let's be clear, this bill really has nothing to do with denial of a choice. This bill has nothing to do with preventing a woman from seeking the termination of her child. What it does seek to do is to prevent the tragedy of a double loss of life, and I would urge support for this bill.
Senator Kent.
Thank you, Mr. President. I appreciate Senator Ralph pointing out that he believes that this bill has nothing to do with the denial of choice, but I think it's worth considering that this bill really has nothing to do with medical necessity. Members, this is very similar to a number of kinds of laws that we've seen implemented around the country. They're frequently referred to as TRAP laws, targeted regulation of abortion providers. And you know, when I did a little research, I looked it up and saw on the ACLU website that TRAP laws are seen as being a concerted, because it is very organized, a concerted and politically motivated effort, one that is medically unnecessary, to restrict access to safe legal abortion. It's interesting, when I looked on the Guttmacher website, and they list the different TRAP laws that have been enacted in states around the country, I was interested to see that to date there is no such type of provision along these lines that is in Minnesota. And so I think it's interesting that we're considering making that change at this time. The licensure requirement in this bill is clearly not medically necessary. Abortion is a very safe procedure with very low rates of complication. Data from the Centers for Disease Control and Prevention, the CDC, demonstrates that abortion has a safety record of over 99%. It's worth noting that clinics that perform other types of medical procedures, from colonoscopies to dental surgeries to liposuction, are exempt from this type of licensure requirement and often have higher rates of complications. But we're not talking about those today. The American Medical Association and the American College of Obstetricians and Gynecologists have said there is simply no medical basis for TRAP laws, that they do not serve, this is a quote, the health of women, but instead jeopardize women's health by restricting access to abortion providers. And because this bill singles out abortion providers, it's clear that this is really about politics and not women's health. You know, in the previous bill, we were talking some about the politics, and I would go back to some of the comments that I made then. People have deeply held beliefs on this issue, and I think it is very important that we be respectful of each other and our beliefs. I think it is also important that we remember that we have thousands of people in our communities who have beliefs that reflect our own, but who may have a different set of belief system. People of faith may believe differently. I'm quite sure they do believe differently than I do. And I know that's probably true for all of us. And I think it's important that we remember to be sensitive to those differences and respectful of it. Because this really is about politics, it's important to understand this in the legal framework. It's worth noting that a similar Texas law was recently ruled unconstitutional. In 2016, the United States Supreme Court ruled that anti-abortion restrictions must be examined for the burdens they impose on women. And finally, I want to point out something that caught my attention about this bill. It includes a particularly troubling violation of privacy for Minnesotans. It requires that clinics report the names and license numbers of all healthcare professionals who work there, and it provides no protection for patient privacy. In Minnesota, as we've heard on this floor many times, we can be proud that we have a commitment and many laws that protect privacy. This bill goes against that tradition, and I think that is highly problematic. It is troubling in general, but it has more serious potential ramifications when we consider the well-established history of anti-abortion violence against care providers. This is a bill that is unnecessary. It violates Minnesotans' access to safe and legal medical procedures. It violates Minnesotans' privacy and potentially their safety, and it is unconstitutional. I encourage members to vote no on this bill.
Senator Fishbach.
Mr. Chair, I'd just like to mention a couple of things that Senator Kent had brought up. This language that we're looking at is significantly different from the Texas law. Yes, that did have portions, I believe, portions or the entire thing ruled unconstitutional. There are a couple of differences that I'd like to point out, in particular in that Texas law. In the Texas law, there were admitting privileges so that the doctors at those clinics were obligated to have admitting privileges to a nearby hospital. That is not in this bill. In Texas, they had already required certain inspections by the state for abortion clinics, and that Texas law that was ruled unconstitutional was requiring additional inspections for only abortion clinics. This law doesn't do that. It does not add that. There was also, in that Texas law, there were also exceptions for certain facilities. This law that we are looking, or this legislation that we are looking at, doesn't do that. The other thing I'd like to point out is Senator Kent mentioned some privacy issues. And I mentioned it earlier when I was discussing the bill, but the privacy rules that we look in here about talking about the records in subdivision 9 of the bill on page 3, that is existing statute. All the health records maintained on each client by an abortion facility are subject to sections 144.29 to 144.298. And that is existing statute regarding patients' rights and access to records. And those are the privacy laws that we're talking about. In addition to one other point that Senator Kent made that I'd just like to point out to the body, there was a discussion about disclosing the names and license numbers of healthcare professionals. And that also is already in existing law, that exact language. It's in existing law 144.615 in regard to birth centers. So I just wanted to make sure that everybody had that full information on those points. Thank you.
Senator Rude on this point. Senator Rude.
Mr. President, I would like to compliment the author of this bill. I think she has listened really carefully as this legislation has moved through the process to all the concerns of the people that supported it and the people that opposed it. I think she's gone to great efforts to recraft the legislation, to make it easier and more possible for qualified abortion facilities to undergo a basic state licensing and inspection process. And I believe that this balance and the goal, it really achieves the goals of what we're trying to do with this legislation in protecting women. That's what this is about, folks, protecting women, making sure that they're safe, and yet not being burdensome on the facilities that do these procedures. So I ask for your support of this bill because it's really about the safety of women, and whether you believe in abortion or don't believe in abortion, a woman, when she makes that very personal choice, should be safe, members. And this bill does that and accomplishes that. So I would like to compliment the author on really listening and changing the bill and putting in amendments that make this a good, solid bill that can protect women.
Senator Marty.
Thank you, Mr. President. Members, this bill, I think we all know it's going to be vetoed, so it would not become law. But if it were to become law, it is unconstitutional. And Senator Fishbach, you were saying how this is different from the bill in Texas. But the test that the courts have used includes whether the benefits outweigh the burdens, whether there's a valid state interest behind it, and whether it's based on credible evidence. And in Finance Committee, I asked you what the credible evidence was that these clinics were less safe than the other 1,250 or so physician clinics in the state, the ones you are treating these 6 differently from. You did not give any. You just said, well, there could be something wrong. You said that other states might have had problems, but you've given no credible evidence, which the court required in order to be constitutional. So it's not constitutional. It clearly is not constitutional. It will fall if it were to become law. The courts would not accept it. But in addition to being a bill that will be vetoed, a bill that's unconstitutional, I want to also argue that it's bad and unsafe policy, dangerous policy. The provision which you said we also do in birth centers, where it requires under the licensure applications, page 3 of your bill, the names and license numbers of healthcare professionals on staff at the abortion facility, that is dangerous. People who work in clinics are at risk. Nationwide, I think there have been 11 murders of abortion clinic employees, 26 more attempted murders. They are targeted, personally targeted. Putting their names out in the public will, among other things, shut down clinics, because trying to find people who work there when their lives will be publicly listed as targets for people makes it far more dangerous. And for those who think, well, not in Minnesota, I remember visiting the director, a tiny woman of one of Minnesota's clinics a number of years ago. Her office has on her coat rack, she has 2 bulletproof vests. She'd wear them to work every day. Why? She was afraid for her life. And I think the reality is most clinic employees are. And I don't think it's a false worry because of what's happened elsewhere, the threats. So this is not a safety provision. If you want to talk about the other 1,200 clinics that physicians run that are also not licensed by a health department, that are governed by the physicians who, in order to not lose their license, have to practice in safe, sanitary, clean, good medical clinics. Some of those, I've been to some of those clinics. There's one in the east side of St. Paul performs colonoscopies, which are higher risk than abortions, much higher risk. And they are licensed the same way. They're regulated by the Board of Medical Practice. If the physicians who work there, if they're running an unsafe practice, they'll shut it down. The same thing here. We have letters from the American College of Minnesota chapter of the American College of Obstetricians and Gynecologists talking about the unfortunate truth is that the enactment of this legislation will harm the women of Minnesota. This is indeed what happened in other states that have limited access. They talk about the specific provisions on page 3, jeopardizing the safety of providers and employees of clinics by requiring the name of the people who work there. Medical Association, MMA, not a radical group, spoken out very clearly about how they see this as a dangerous overreach into the patient-physician relationship. Picking out some clinics based on one type of medical procedure and saying, we're going to treat you different than everybody else. Not based on any, Senator Fischbach, on any credible evidence, which you, when asked in Finance Committee, didn't come up with any reason. There's no credible evidence these are more dangerous. They're less dangerous. There's no credible evidence that these should be treated differently than other clinics. And the one thing we do know is if you were to follow through on this and make public the names of the people who work there, their lives would be at much greater risk. I urge you to reject the bill and get back to the process of things that we need to be doing this year, not trying to pass this bill which the governor vetoed several years ago.
Senator Matthews.
Thank you, Mr. President. I'd like to impose a call of the Senate for the duration of the bill.
Senate's under call. Okay.
Oh, this is just the call of the Senate. So, yeah, exactly.
Senator Matthews.
Thank you, Mr. President. I move that further proceedings under the roll call be dispensed with and the Sergeant at Arms be instructed to bring in the absent members.
All those in favor say aye. Opposed? Motion prevails. Secretary will close the roll. Further discussion, Senator Draheim.
Thank you, Mr. President. And thanks for the discussion, fellow senators. Yeah, I'm reminded as I sit here listening to everybody how diverse our Senate really is. And I know a lot of people here are, we had some doctors, nurse, attorneys, a lot of people that worked for government or academia. I come from the business world where inspections and licensing is standard. It's just commonplace. And I know a lot of industries would love to set the rules and the guidance on what's inspected and what's licensed. You can't go to a fair and sell corn dogs without being licensed and being inspected. Thank you.
Senator Pappas.
Thank you, Mr. President. I have the A2 amendment.
The Secretary will report Senator Pappas's amendment.
Senator Pappas moves to amend House File Number 812 as follows. At page 1 after line 5, insert. This is the A2 amendment.
Senator Pappas.
Thank you, Mr. President and members. I think if the goal of this legislation is to reduce the number of abortions, then I think it's really important to support this amendment. What this bill would do would guarantee contraceptive coverage without cost sharing. It would require insurance companies to cover birth control prescriptions for up to 12 months at one time, which has been shown to decrease costs for health insurance companies and decrease rates of unintended pregnancies. And it would eliminate cost sharing for patients with no deductibles, co-insurance, or co-payments. This amendment will guarantee reliable, affordable access to birth control. Access to contraception prevents unintended pregnancy and reduces costs. 99% of sexually active women have used at least one type of birth control in their lifetimes. When women at risk for unintended pregnancy use contraceptives consistently and correctly throughout the course of any given year, they account for only 5% of all unintended pregnancies. Plus, women are more likely to use the contraceptive method that they choose in consultation with their doctors. Women consider many factors when choosing contraception: their personal and family health history, the side effects of the drug, whether or not they've already have children, ease of use, the effectiveness of the method, and the cost. When insurance companies try to dictate which method women should use by denying coverage or requiring pre-authorization, women are less likely to use birth control consistently or correctly. Finally, for birth control to be effective, consistency is essential. For many women, whether they work multiple jobs, lack reliable transportation, or live in a remote area of the state, receiving only 30 or 90 days of contraception at a time can be an obstacle to effective use. Most women receive only 1 month of birth control pills at one time, forcing them to return to the pharmacy monthly, and often only within the time period allotted by their insurance companies. The 2013 Centers for Disease Control and Prevention recommendations include dispensing contraception for 12 months. I'd appreciate your support in preventing unintended pregnancies.
Oh, Senator Fischbach.
Mr. President, I'd like to raise a point of order under Rule 35, germaneness. I do not believe that the A2 amendment is germane to the bill, and I have advice.
Please give advice.
Mr. President, this is, I think in your words, far afield from the original intent of this bill. This talking about contraceptive methods and counseling and providing contraceptives. This is about licensing a medical clinic and has nothing to do with this at this point, and it is a different portion of law.
Further advice. Senator Pappas.
Thank you, Mr. President. I withdraw the amendment.
Senator Pappas withdraws the amendment. Any further discussion? Senator Dibble.
Thank you, Mr. President. Mr. President, I just wanted to refer back to a question that was asked by Senator Kiffmeyer, Senator Schoen, who provided a great answer, but I wanted to provide a little bit more detail because I immediately went to the internet and pulled up the information with specificity. I think the question implied that Planned Parenthood solely provided abortion services, and Senator Schoen did a good job of disabusing the chamber and the public of that impression, but I just wanted to read for the record the kinds of things which constitute about, I think, 97% of everything that Planned Parenthood does. In summary, it provides expert sexual and reproductive health care services for everybody, with some of the best trained, most experienced experts in women's health. They offer a level of non-judgmental care that's hard to find anywhere else. For women, under the category of wellness and preventative care, they provide annual exams. They provide a whole array of access to all forms of birth control, the morning after pill, and for fertility awareness education. In terms of vaccinations, provide access to HPV vaccines and hepatitis B vaccines. And they provide a variety of laboratory and testing services, Pap tests, STD testing and treatment, urinary tract infection testing and treatment, other forms of treatment for women, HIV testing, education and referral, pregnancy testing, and options counseling. And they also provide advanced gynecological care, including abortion services, of course, colposcopies, and LEAP, which is a treatment, Escher, which is a long-term IUD, and care in the instance of miscarriages. And they can fill prescriptions and contraceptives on site. For men, they provide information and testing and treatment for a variety of issues, including checkups for reproductive and sexual health issues, STD testing and treatment, vasectomy, and access to men's contraception as well. Mr. President, I think it's important to know that Planned Parenthood is a place where anyone can go to get their needs fulfilled and in a way that is safe and secure and confidential, that many, many, many people lack access to for a whole array of reasons, whether their own insurance doesn't provide for it, whether they have income issues, and they need this kind of access. Thank you, Mr. President.
Thank you, Senator Dibble. Senator Fischbach? Senator Kiffmeyer.
Thank you, Mr. President. Well, in response to that, just so we all know, though, if you have Medicaid coverage, all of those things that are mentioned there are more than covered under their regular physician and in a much more comprehensive way, for sure. And so I think we just need to know that if they have Medicaid coverage, all of those things are already covered, services provided to them, and more comprehensively in the needs that they have with the privacy and everything else that goes with that. Thank you, Mr. President.
Further discussion? Senator Fischbach?
Mr. President, I have the A50 amendment.
Secretary will report the Fischbach amendment.
Senator Fischbach moves to amend House File 812 as follows, page 3, line 2, after facility insert. This is the A50 amendment.
Senator Fischbach.
The A50 amendment I just had put together, and I think Senator Ruud talked about how we've been trying to accommodate some of the concerns regarding this bill, because our issue here is to make sure that women are in safe clinics and being treated well and properly. And so I know that I heard Senator Marty's concern, and so this amendment would, after the line, on page 3, line 3.1, so the names and license numbers, if applicable, of the healthcare professionals on the staff at the abortion clinic, and we would say any identifying information shall be redacted in public documents. And so I understand that Senator Marty brought up a concern, and so I was trying to address it with the A50 amendment.
Further discussion on the Fischbach amendment? Senator Dibble?
Well, thank you for the responsiveness to the confidentiality issues, but I think Senator Limmer and Senator Kent and others who pay attention to these privacy issues know that simply redacting information in public documents does not make the information private. It needs to be designated and classified as private data so that, in fact, it becomes a violation of the law should any of that information get out into the hands of people who should not have that. And there is a very solemn responsibility to keep that information private the way we treat the information providers at every other similarly situated healthcare facility in our state. So simply a redaction doesn't create a solemn legal responsibility to keep personal information, keep people's lives and safety out of danger.
Senator Fischbach.
Mr. President, I was simply trying to address some of the issues that people were bringing to my attention. But if this doesn't satisfy it, I will just withdraw the A50 amendment.
Senator Fischbach withdraws the amendment, the A50 amendment. Any further discussion? Hearing none, the Secretary will take its third reading.
House File Number 812, a bill for an act relating to health requiring licensure of abortion facilities.
Secretary will take the roll. Yep. 33 or 63? All senators having voted, the Secretary will close the roll. There being 35 ayes, 29 nays, the bill is passed and its title agreed to.